Namaskar. Emergency provisions. President can make proclamation of emergency under Article 352 in case of war, external aggression, or armed rebellion, or or threat thereof only on recommendation of the cabinet, and threat thereof only on recommendation of the cabinet. Every such proclamation must be laid before Parliament, and it ceases to be in operation unless it is approved by resolution of both houses of Parliament with a special majority within 1 month from the date of its issue. The proclamation gets a fresh lease of 6 months from the date it is approved by both houses of Parliament. After the 44th Amendment, proclamation of emergency under Article 352 can be made in respect of whole of India or only a part thereof. During proclamation of emergency, the Union can give direction to any state regarding exercise of the executive power. Reference Article 353A. During emergency, Parliament can extend the normal life of the Lok Sabha for 1 year at a time, and not exceeding 6 months after the proclamation has ceased to operate. Normal life of Lok Sabha was extended only once since 1976. During emergency, Parliament can legislate regarding state objects. During emergency, the President can modify the provisions of the Constitution relating to the allocation of financial resources, Article 268 to 279, between the Union and the state by his own order. Such order is subject to approval by the Parliament, Article 354, and has no effect beyond the financial year in which the proclamation itself ceases to operate. Effects of emergency on fundamental rights. Article 358 provides that the right provided by Article 19 would be non-existent against the state during emergency. Under Article 359, the right to move the courts for the enforcement of the right can be suspended by order of the President. Article 20 and 21 cannot be suspended during emergency. The first proclamation of emergency under Article 352 was made by the President on October 26, 1962, in view of Chinese aggression in the NEFA. For the first time on June 25, 1975, proclamation of emergency under Article 352 was made on the ground of internal disturbance. A proclamation of emergency for failure of constitutional emergency can be made by the President when the constitutional government of state cannot be carried on for any reason. Reference Article 356. During emergency under Article 352, the centre does not get power to suspend the state government. In case of failure of the constitutional monarchy, the state legislature is suspended, and the executive authority of the state is assumed by the President. In whole or in part, this is popularly called the President's Rule. Under a proclamation of emergency under Article 352, Parliament can legislate in respect of state subjects only by itself. But under a proclamation under Article 356 of the other kind, it can delegate its power to legislature for the state, to the President or any other authority specified by him. Proclamation of emergency for failure of constitutional machinery can be extended by Parliament up to 3 years. Article 356 for provision 1. धन्यवाद.